Law firms don't usually represent themselves in legal proceedings, but an increasing number of firms are being targeted by cybersquatters and taking action under the UDRP, the Uniform Domain Name Dispute Resolution Policy, to enforce their rights as trademark owners. In one recent case, the Bryan Cave law firm filed and won a UDRP complaint for a domain name that is almost identical to the firm's own domain name and registered trademarks. Here's what happened in the case. Bryan Cave, which is an international law firm with more than 1,400 lawyers in 31 offices around the world, filed its UDRP complaint at WIPO, the World Intellectual Property Organization, in October 2021, and received a decision ordering transfer of the domain name in December 2021. Now, that's a typical timeline for a UDRP case, which I usually tell my clients takes about 2 months from start to finish, depending on what may arise during the course of the proceeding. The respondent, or registrant of the domain name against whom Bryan Cave filed the complaint, had originally used a privacy service when registering the domain name, also something that's common in UDRP cases, and it didn't bother to file a response, another frequent occurrence. The disputed domain name was bclplawv.com, which is the same as Bryan Cave's own domain name, bclplaw.com, except for the addition of a letter V at the end, which frankly might not even be very noticeable when viewing the domain name quickly, given that it sort of blends in with the preceding letter W, something that I'm sure was not an accidental decision made by the cybersquatter. According to the UDRP decision, the domain name was used not in connection with any sort of active website, but instead to impersonate one of Bryan Cave's own attorneys in an email soliciting payment for a fake invoice for legal fees. Now, this type of scheme seems to be a growing tactic used by cybersquatters. I know I've represented clients who have encountered the same thing, someone else registering a domain name and targeting their customers for payment. The real victims, of course, are the customers who might pay these invoices unaware they're not legitimate. But ultimately, it's the trademark owners who can really do something about it by doing what Bryan Cave did in this case, filing a UDRP complaint. And here's how the case turned out. On the first element of the UDRP, the panel easily concluded that the disputed domain name was identical or confusingly similar to Bryan Cave's trademark registrations. Now, fortunately, the law firm did not rely on its own domain name registration, bclplaw.com, which is usually not sufficient for establishing trademark rights under the UDRP. And instead, Bryan Cave cited 2 trademark registrations in the United States and the United Kingdom for BCLP and BCLP law, which were obtained only in recent years, despite the fact that its founding law firms date back more than 140 years. But for purposes of the UDRP's first element, dates are not really relevant. And the only issue is whether the complainant, in this case Bryan Cave, has trademark rights, which it easily established by citing its trademark registrations, and whether the disputed domain name is identical or confusingly similar to those rights. And on that issue, here's what the panel wrote. It is well established that domain names which consist of common, obvious, or intentional misspellings of trademarks are considered to be confusingly similar for the purposes of the first element of the policy. In view of the evidence proffered by complainant, the panel agrees with the conclusion that respondent purposefully added the letter V to the disputed domain name as a typographical variation camouflaged with the preceding letter W in the word law with the intent to confuse and misdirect internet users. In view of complainant's registrations for the BCLP and BCLP law trademarks, respondent's incorporation of complainant's trademarks in their entirety in the disputed domain name, and respondent's clear attempt at typo squatting on the BCLP law trademark, the panel concludes that complainant has established the first element of the policy. The panel then assessed the second and third elements of the UDRP together, given what it said was strong evidence establishing that the disputed domain name was being used to impersonate a Bryan Cave employee to fraudulently solicit payment. Specifically, here's what the panel wrote. Complainant has provided as evidence an email with the subject line invoice sent by respondent from an @bclplaw.v.com email address to a client of a complainant. In that email, respondent attempts to impersonate an employee of complainant and asserts, "The wire is not yet received. There was a bad check deposit into our account. Due to this, bank has placed a hold on our account until this issue resolved. We need to change our banned account details." The panel considers this email to constitute uncontroverted evidence that respondent has registered and used the disputed domain name in bad faith, in furtherance of respondent's illegal scheme to defraud complainant's clients. Now, unfortunately, it's impossible for a trademark owner to anticipate every potential domain name registration and how it might be used. So there's really no way Bryan Cave could have stopped this attempted scam in advance. And when these scams prey on large law firms, there's a pretty good sign that just about any company is a potential target. Fortunately, filing a UDRP complaint is a very effective way for trademark owners to shut down these types of fraudulent email schemes, seeking payment for fake invoices once they actually arise. If you want to learn more about the UDRP, please check out my masterclass on domain name disputes, as well as other resources on my GigaLaw website. And be sure to subscribe to the GigaLaw YouTube channel to be notified of future videos discussing other internet legal issues. Thanks for watching, and see you next time online.